Good afternoon, everybody, and welcome. This is our annual Emroch Lecture series. The lecture was created by Mr. Emroch and his wife, Bertha, and continues to be supported by his son, Walter, and daughter-in-law, Karen. Just a word about Mr. Emroch. He was a 1931 graduate of the law school and had a very distinguished career as a trial lawyer. He was founder and past president of the Richmond and Virginia Trial Lawyers Association and a member of the International Academy of Trial Lawyers. He was also founder of the Richmond chapter of the National Conference of Christians and Jews and was chair of the committee that successfully secured enactment of Virginia's anti-discriminatory advertising law. In 1974, he was honored by the NCCJ with that organization's Humanitarian Award. And so we're very proud, given that history, to welcome our speaker here this afternoon. I'm going to turn things over to Associate Dean Allison Tate, who will introduce our speaker.
Great. Well, thank you, everybody, for being here. As Wendy said, we're so delighted to be hosting Professor Kapczynski and to be holding the Emroch Lecture again. And we're just happy to have Amy here in general because she's a fabulous person. I think we're going to have a great talk. She is a professor at law at Yale Law School, and she is also the faculty co-director of the Law and Political Economy Project and the co-founder of the Law and Political Economy blog. She's also the faculty co-director of the Global Health Justice Partnership. She does a lot of things. So she's here to talk to us today about LPE. Her research focuses on law and political economy, as you might have guessed at this point. And you might be wondering what law and political economy is at this point. But I think we're going to hear about that today. A little preview. Her research focuses on the failures of legal logics to provision people in general and to facilitate democracy. And her research also focuses on conditions that create inequality, financial precarity, and the failure of democracy and democratic systems. Within the LPE world, her primary areas of focus include health justice and the political economy of technology. So she's done a lot of theoretical work. She's also done a lot of practical work, and she turns her theory into movement work. She's worked closely with social movements involved in campaigns for access to medicines in the US and transnationally. And more recently, she's been part of a coalition calling for a community health court to combat COVID-19. So prior to joining Yale in 2012, Professor Kapczynski taught at the University of California at Berkeley. And before that, she served as a law clerk to Justices Sandra Day O'Connor and Stephen Breyer at the U.S. Supreme Court, in case you were wondering. And she was also a clerk for Judge Guido Calabresi on the U.S. Court of Appeals for the Second Circuit. So please help me welcome her today. We're so delighted to have her here, and so looking forward to all of the things she's going to tell us about law and political economy.
Thank you so much for the invitation to join you all today and for joining me despite the sunshine out there. Really, really appreciate the chance to get to talk about this set of ideas. And so here's what I want to do. Broadly, what I want to do is take some time, I'll leave a little bit of time for Q&A at the end, to talk about the, I would say, emerging legal movement or approach of law and political economy, and kind of where it comes from, what I think it means, and sort of situating a little bit in legal theoretical movements more broadly, and also sort of where it's going. So let me start with the first question, which is sort of why law and political economy. So, I'm proposing, this sort of brash idea. There's sort of a need for and maybe an emerging new legal school of thought. Why do that? Why spend our time together in this room thinking about this? And as I think about that and sort of where I entered, sort of why I put my energy into trying to think about and create space for what I'm going to talk about is LPE. Here's one place that my mind goes to. So these are all pictures of people who died a couple of years ago because they had type 1 diabetes and they could not afford insulin. These are all young people. They are probably poorly insured. That's one way to think about what happens. They're, as you can see, often people of color. They were gathered by a group called T1 International that I've done some work with. It's an activist group that works on advocating for people with type 1 diabetes globally, but also in the United States. And part of what their work has helped to show is that the price of insulin is a drug that you absolutely need if you have type 1 diabetes, lest you, in fact, risk grave disability or death. The price of insulin, although the drug has not changed at all, over the last 10 years went up by 400%. So, people face co-pays of hundreds of dollars, even sometimes $1,000 a month, given that problem. And this is in the wealthiest country in the history of the world, and a drug that hasn't changed at all. Right? How did this happen? Right? And my work, as Allison mentioned, goes back further. I actually got into these issues working not on access to medicines in the United States, but actually brought tools to the United States that I learned working on global access to medicines issues, where when I entered as a law student, I was already connected with AIDS activists who are working on access to HIV medicines. And those medicines, as activists then taught me, cost $10,000 to $15,000 per person per year to buy from patent-holding companies, even though they cost less than $100 to make. Right? And so that campaign was about sort of trying to bring medicines to people and grapple with questions about why they were so unaffordable. I'm happy to say more about any of that in the Q&A, but that's the point that I come into these issues with. This is somebody who's cared about, worked on sort of a little bit in the trenches, access to medicines issues and health justice issues, and confronting this puzzle. Why are these drugs so expensive? Why are the prices rising? Right? You immediately confront questions of economics, of the structure of our economy. And one of the things that I learned through that advocacy work was that there were a lot of arguments being offered why the state of the law sort of had to be what it was, but that actually were not well-founded or persuasive. Obviously, you probably already know that often the justification for the high cost of drugs is, well, the expense of innovating. But that doesn't tell you about insulin, right? It's not a new drug, old drug. Cost goes up tremendously. In the access to medicines movement more broadly, one of the things that we discovered was that although the justification was innovation, there had been no new drugs for diseases like tuberculosis or malaria in, again, decades, right? And so something didn't line up. So these were the issues that got me into questions of political economy and got me sort of interested in, and to really feel the urgency of questions about sort of the standard narratives that, I was taught when I came into these questions and also came into law school about the economy and how it works, and the disconnect, the really radical disconnect with people's experiences of the economy. And so broadly, one way to think about what law and political economy is a framework that people coming with different kinds of questions, so for me coming from health justice, but other people coming from different places, and different kinds of crises, so whether they're interested in precarious work and the experience of low-wage workers today, or they're interested in the growth of the carceral state, or the persistence of racialized injustice despite ostensible commitments to non-discrimination in our law, or they're interested in the climate crisis or the care crisis, or generally economic stagnation and a sense of sort of hollowed out democracy, financialization, the dynamics of sort of a sort of runaway and crisis-prone banking system. Or concentrated corporate power in the economy. There's a lot of evidence that we have more concentrated corporate power in the economy today, and that it's having bad effects on wages and innovation. People interested in these kinds of questions of political economy from different directions, broadly, who are trying to describe and identify how the legal orders that we have helped contribute to these problems and how to change them. And so broadly, I'll say more about some of the ideas, but sort of one way to think about what law and political economy is really is a group of initiatives and organizations and people. So here's some of them I've put up here. We have a Law and Political Economy Project has a website. We have syllabi, we have events and archives, we have a blog, we have student groups. There's more than 30 student groups around the country now. There's also kind of associated organizations like Appeal, there's a Journal of Law and Political Economy. So there's a kind of a growing ecosystem that is emerging to really center questions of political economy. And by that, what I mean is, and sort of come to this, what do we mean by political economy, right? So what I mean by political economy here, and what we're using the term to mean, is not what you might have come across if you took economics courses, or you think about this through the lens of sort of classical economics. The term political economy in a kind of mainstream economics department now would actually be using the tools of neoclassical economics to kind of model the state like a market actor and ask about incentives and model rational actors in the way that people in economics would do that. I don't mean that. Instead, what this kind of group of people is interested in is what I would call more classical political economy, in the sense of Adam Smith or Ricardo or Marx, people who are asking, how can the economy be moral? How should we structure the economy? And recognizing that politics shapes our economic order and that economics shapes our political order, right? These things interact with one another, hence political economy, right? And so the economy is not a thing that follows its own rules, but rather something that we shape. And of course, in some ways, this is a very natural idea that goes back to the legal realists. And for lawyers, you take a property class, you take a contracts class, you know that terms that in economics, they're often kind of reified or treated as if they're just sort of a thing. Like, there's a market in this thing, like somebody had to make it so. There's rules about, what's property and what isn't property and when there can be exceptions to property and so forth. So what law and political economy is in the broadest sense, I think, is a group of people interested in reviving questions of classical political economy, the morality of the economy, the structure of the economy, and thinking about sort of how does law create the connective tissue between sort of politics and the economy. More broadly, I think, starting with these various crises, it's also a group of people and an approach that is asking about how the conception about the relationship between politics and the economy that maybe has been present in legal thought recently, that treats, in fact, despite the things we might know when we're in a property class, that in fact talks about the market as if it's a thing, or talks about the economy as something that kind of follows its own rules and needs to be left alone, resisting that idea, right? And so insisting that in fact the economy is fundamentally politically and legally constituted, and that we should therefore investigate questions of political economy and think about how we should order our political economy. Okay, so another way to sort of draw connections between different kinds of questions of, that people are grappling with, the crises in the world, and the questions that we're asking in law schools, is to think about, like, what kind of political economic order do we have? How do you sort of describe the political economy that we live in? And here, I'm going to draw a little bit on a piece that I wrote with some co-authors in the Yale Law Journal it's called Towards a Law and Political Economy Framework, thinking, and part of what we propose in that is that we need terms like neoliberalism, which is a big word, which probably you've heard before, but I'm going to say a little bit about what I think it means, to understand the political economy that we have and to understand how law, in fact, morphed and changed to, in fact, enable, or at least not disrupt, some of these kinds of dynamics, whether from insulin to concentrated corporate power to, in fact, also the sort of aggressive accumulation of power in the carceral state to, environmental crises and so forth. Okay. So we we sort of describe the kind of the law schools that we came into, and there's a sort of generational cast to this LPE stuff. It's not solely people of my rough age, but a lot of us are. And it's partly like reacting to the law schools that we came into and thinking, we came into law schools, and maybe some of you students can relate to this, thinking law schools were a place that we would talk about justice and power, and instead found that particularly in our first semester courses, instead, when you come into a course like torts or contracts and you're talking about efficiency, and at least you have to be literate with those kinds of ideas. And we're often talking about neutrality instead of power. So broadly, we are trying to sort of describe some of the changes in how our both formal law and how we interpret and think about law have some of the changes that have happened over the last several decades through the lens of neoliberalism, and arguing that some of the kind of crises that we're talking about have been accelerated by the use of legal discourse to bring neoliberal ideas into law and to then restructure our political economy accordingly. And in some, so this is a good moment to talk about what I think neoliberalism is. So here's one definition, which is like a conventional definition by David Harvey. So neoliberalism is a theory of political economic practices that proposes that human well-being can be best advanced by liberating individual entrepreneurial freedoms and skills within an institutional framework characterized by strong private property rights, free markets, and free trade. So this is the kind of thing that the literature, and there's a big historical literature on neoliberalism, sort of talks about. It's a sort of theories of free markets or deregulation associated with Ronald Reagan, Margaret Thatcher, if you work transnationally, the Washington Consensus or the IMF, with the basic idea, let markets do their work, prevent politics from interfering with markets, because that's the way we're going to grow the pie, we're going to get more efficiency, and broadly offer choice, right? So there's a whole rhetoric that goes along with this. So scholars of neoliberalism describe this as in some ways the latest phase of our political economy, in the sense of like neoliberal capitalism, that's the political economy we live in, as following on from and in some ways a reaction to the New Deal, right? And so there's a lot of very interesting scholarly work about people like Friedrich Hayek and Milton Friedman and the Mont Pelerin Society, right? So there are real thinkers and academics who are reacting to certain kinds of status quo of the New Deal in the 50s, right, where you have relatively high power for labor, relatively high tax rates, relatively low inequality and social mobility, and you also have on the global stage decolonization. And they're reacting also on the domestic stage to anti-racist movements of the civil rights era, and in reaction to all of these things, reviving a certain set of classical ideas of economic liberalism called laissez-faire often, and trying to re-articulate them and give them a new expression to resist some of the kind of, I think, combination of things going on in the anti-colonial civil rights post-New Deal moment. So as I mentioned, these are ideas associated with people like Hayek and Friedman that really took root in policy in the 1980s. So key examples of the kind of policies that are associated with neoliberalism, so deregulation, anti-labor union, cap and trade, so as a sort of market mimicking, right? If you have an environmental problem, create a broad-based carbon tax or a cap and trade kind of system, things like that. Cost-benefit analysis inside the regulatory state. When I started working on access to medicines, I learned a lot about the WTO, a creature of the 1990s that was, again, adopting a logic of free trade, ostensibly. So notice that this is not what I've described, not like a left-right list. Like part of the story of a new consensus about political economy and neoliberalism is that it was shared across the, not in every aspect, but the Democratic Party moves very much in this direction, and this is how you get the kind of sense of the new paradigm. In fact, I think there's a better way to understand what neoliberalism is than this definition, which is to say this one. From David Grewal and Jed Purdy, which is to say that the common way of describing what neoliberalism is the idea of sort of freeing markets, right? But that sort of already is to suggest that there's a way to have a free market, and that a free market involves a minimal state. And that's not obvious, right? As somebody who worked and came into these issues around access to medicines, like what was happening was a country like South Africa had signed on to a treaty that meant that it had to adopt patents on medicines. Now, is that deregulatory or regulatory, right? So it's actually, I think, a mistake to think of this as a deregulatory sort of phase, in fact. But rather, and this is I think, a better way to think about it, neoliberal claims advance the market side of this contest in capitalist democracies between capitalist imperatives and democratic demands. It names a suite of arguments, dispositions, presuppositions, ways of framing questions, and even visions of social order that get called on to press against democratic claims in the service of market imperatives. So the idea behind this way of thinking about it, I think WTO is an interesting example of this, right? The WTO tells countries, you must do this if you want to enter into the global trade order. You must have patents on medicines, for example, right? And this elevates the power of people who can profit from markets and disables democratic institutions from being able to enact a sort of a redistributive paradigm. And if you think about labor law, again, like there's something that has to happen. Law has to redistribute power to help, sort of diminish labor, the power of labor, and increase the power, let's say, of firms. And law changes in a whole lot of ways over these several decades precisely to do that. So not deregulating so much as re-regulating. And in fact, also building out state power in a way that I think if you, again, think about these same periods, 70s, 80s, 90s, these are periods where a lot of state power is being built out. And those of you who work on criminal justice questions know that very deeply, or questions of migration, right? And so this way of seeing it can, I think, help us also link together things that are often really foundational to shaping the economy, but not necessarily thought about as part of it. Okay, so rather than naturalize the free market or regulation, rather this is also foregrounding questions of political power and the idea that the state is making markets and therefore is necessarily distributing political power along with it. So the key is thinking about this as a political move that's elevating the idea of some kind of self-governing economy, but not actually that thing, and highlighting that it's in some tension with democratic politics. So how did these ideas get into law? So this is what we sort of rashly call the 20th century synthesis, trying to describe, again, the world of law schools that many of us came into, where there was a sort of, although people didn't talk about the public-private distinction, there was a sort of reinscription of the public-private distinction, right? So the courses that were quote-unquote about the economy, courses like torts or contracts, or course that I teach, intellectual property, these courses were broadly ones where you now had to talk, maybe not only, but very foundationally about efficiency. And then you had courses on the sort of public law side of the curriculum, let's say a course about constitutional law or anti-discrimination law, where often you didn't really talk about the economy, but maybe naturalized the way that it worked. And so I'll say a little bit more about both of these, because part of what we're trying to do here, and I think people who are interested in how legal ideas sort of helped reshape how law structures the economy, are trying to show that the rise of a certain set of ideas, and let me talk first about the private law side, in which case we're going to talk about ideas associated with law and economics. Like, how did those ideas actually come to reshape how we talked about the economy and the law's role in shaping it? So we, broadly, I think, if you look at the kind of history of law and economics and how it operates and is taught in law schools and talked about in policy debates, you see this sort of broad reconstruction of areas of law having to do with the economy as about efficiency. So what do you do here? And so those of you who've taken a course on IP, or probably some of your first semester or first year courses like property or contracts, maybe taught through this lens, right? That you take the tools of neoclassical economics, you apply them to law, so you model people as sort of, well, rational maximizers trying to get efficient outcomes because that's a good or neutral value. And you take as a goal, when somebody says to you, like, well, what's the efficient outcome here? There's an implicit, actually normative definition of what efficient is. It doesn't actually mean don't waste resources. It means something very particular. It's a definition that is what technically is typically wealth maximization. The idea that you should, in fact, move resources to people who have the highest ability to pay, right? That's technically what efficient means. And if you think about, if you've encountered this idea in class, like, why would it be good to let the factory pollute or not? Or why would it be bad to have rent control or not? Or why would it be bad to have caps on, interest rates or not? The reasoning that you're going to be offered when you're told to think about what the efficient outcome is about how to allow goods to move to those who value them most in markets, which is really those who are willing, which is also to say able to pay the most, right? So there's a very big, you may not be subjected to this in your kind of core curriculum, but there's a very big academic literature sort of affirming that this is how we ought to think about the world, right? That we should do the efficient thing, and then there's another sort of additional development, which is not only should we do the efficient thing, but we should always take efficiency and do that thing first, and only think about distribution later. That always comes second, right? Distribution comes later. And there's a broad description of markets as operating in certain kinds of ways, right? One of my favorite jokes that somebody once told me about, it's not exactly, friendly to economists, but it's a joke about, an economist and his friend are walking down the street, and the economist sees a $20 bill and walks right past it. And the guy says, "Wait, why did you walk past it?" And he says, "Well, because it can't be there, or somebody would have already picked it up." Right? So there's sort of a story about markets have this seamless quality where if there is a source of power, people react to sort of make that power disappear. And so they're generally competitive, generally good information, right? And we should just assume this set of things. I think we lived through a recent pandemic that I think revealed that is not a good empirical picture of the world. And in fact, supply chains are real. They don't react seamlessly, right? So there's a descriptive story that if you buy that descriptive story, it becomes very hard to locate things like coercion in markets because people just are being paid their marginal product, as long as markets are, now I think there actually are still forms of coercion, like who starts out with the entitlement to, to the firm or to their, So there are still ways to talk about power, but power often sort of disappears in that story. There can be no market power in the classical economic sense if there's a lot of competition, for example. So this way of sort of centering a particular description of markets and efficiency foregrounds certain kinds of things. That things should go toward people with the highest willingness to pay, and sort of sets aside or puts into the background questions of distribution, questions of coercion, and so forth. And so a common way that this is taught in the first year curriculum is to teach the Coase theorem, right? Did any of you get taught the Coase theorem? I'm getting some nods. Yeah. So let me be the first to tell you, if you have not yet learned the Coase theorem, you've probably learned about this sort of rough idea because it's a very foundational idea in law and economics. That here we have a conventional legal problem. How does nuisance law think about this factory? Here comes a factory, and we have the question, it's spewing smoke into the air, and so should that be treated as a nuisance or not? The homeowners next door don't like it, but the factory wants to pollute, and the law is uncertain. How should we decide the question? So Coase's famous article talks about this problem and says a bunch of things, but the way that this is commonly taught is that, how should we think about this issue? Well, we should largely think about it through the lens of a market, right? So what's, one piece is how do you ask the question? Well, I put the little dollar signs below. Ask the question kind of where is there value in markets? So if it's more valuable for the pollution to happen than the kind of cost to the homeowners, then you should factor that in and roughly assume that the thing that has the highest value, so the pollution, should happen. Generally, now it might or might not, and this is where Coase's whole idea of transaction costs comes in. If in fact you give the right to the factory holder to let them pollute, then if it's not, if there are no transaction costs, then the homeowners will be able to buy the right if we misallocated it the way the market wouldn't want it to go. But if there are transaction costs, you won't be able to do that, right? And so sometimes the description is then the next thing you should do is figure out where the transaction costs are highest and then allocate the legal right accordingly. So there's a bunch of different moves that go on here. But what I want you to notice in the way that the Coase theorem works is it's a normative description of what we should pay attention to. So we should think about markets and how markets value things. So where are the dollar signs going to go? We should assume that the market will simply have its way with us, right? Like such that if there are no transaction costs, like the markets just, like the legal rules don't even matter. The market just operates and does its thing. We should also not care about distribution, because the question actually of who to give the entitlement to is about how do you maximize willingness to pay effectively? How do you maximize producer and consumer surplus? Not, how do you maximize health, or how do you how do you throw the question back to politics? There could be all kinds of ways in a law school you might say we should answer this question. You also do, in fact, marginalize questions of distribution. So, if you think about what happens in the entitlement that you assign here, like if you give the right to the factory, then in fact, if you give the right to the factory, and let's say this is the highest value use, they don't have to pay the homeowners to be able to do it. But if you give the right to the homeowners, even if you assume that they'll buy it back, they are going to get paid. So there's huge distributional questions that kind of just get put into the background and always shoved elsewhere. So these are kind of pieces of critiques of law and economics that I think those of us interested in law and political economy are not often innovating, but just sort of drawing together and trying to kind of mobilize to help explain, like, how did this way of thinking about things, in fact, help generate more or make it easier to generate inequality. Well, one way of thinking about that is if you're going to use willingness to pay as the metric of what the good thing to do in the world is, there's a systematic bias towards people who have an ability to pay. And so if you're deciding, do I cite a park? How do I cite a park? Let me use cost-benefit analysis and decide where is their highest willingness to pay for a park. And let me do that by modeling how much do these two communities spend on fitness equipment. Like, guess what? Communities that have more ability to pay are going to be willing to pay more, right? So there's a kind of a systematic accession principle inside of a metric like wealth maximization, right? So mining these kind of early critiques, I think, of law and economics can be helpful to show how, when you take ideas like this, that willingness to pay is how you ought to, say, govern a dispute about whether a factory can pollute, can generate more inequality. Or if you take people writing about the changes to antitrust law that people like Robert Bork helped to introduce, who said, look, low consumer prices are the most important thing. Again, so if you look in different fields, you see these ideas sort of working in slightly different, they get cashed out in slightly different ways. But when you look into antitrust, you see that the way these ideas from law and economics were imported really helped to make it much more difficult to challenge mergers and much more difficult to ask questions about, let's say, the political power that mergers of a certain kind might enable, or the impact on labor, for example. So I teach property. So another way to think about this is the difference in thinking about property through the lens of a sort of foundational law and economics argument like Harold Demzet's versus the way you think about it if you start with Johnson versus McIntosh, right? Johnson versus McIntosh is a story about property and its foundations in the United States. This is John Marshall that you have over here on this side. That says, like the sort of core of Johnson versus McIntosh, if you recall the case, is John Marshall's famous quote, "Conquest gives a title which the courts of the conquerors cannot deny," right? Property is about power and conquest. That's a very different story than you get from Harold Demzet's. It's not about power, it's about efficiency. It's about the reason we have private property is because, there are efficiency benefits to enclosure, basically. So again, you can, in different fields, this logic kind of highlights and works in slightly different ways, but broadly helps to sideline. Part of why property, I think, piece is helpful to see is that you can see the way that the ideas of economy are intertwined with a certain kind of looking away from, let's say, in this context, a racialized history of dispossession, right? So you could see the sort of integration of questions of political economy and questions of a kind of structural racism. Okay, so broadly speaking then, this is like an attempt to sort of sketch for you quickly a lot of work that people are doing to try to tie together an account of how ideas that circulate through legal scholarship come to actually have an impact on the world. As I say, some of that is influence in legal decisions, but also in law change, in advocacy, in regulations, and so forth. And it's not only on the sort of quote-unquote private side. On the public side, one of the things that we try to highlight in that piece that I mentioned is that largely the economy retreats as a site of struggle. So if you take constitutional law, in an earlier period, you might have talked about labor, and you certainly, labor disputes were at the core of the history of the power of the courts in the United States, the history of the moment of crisis, of court packing, right? But the constitutional law today would often not have been, when I went to law school, labor law wouldn't feature in those discussions, right? And also you see in this same period a sort of hollowing out of rights against discrimination to take away any sort of ability to claim a material basis to rights. Like, so I put in cases like Harris v. McRae, which is about abortion, and San Antonio versus Rodriguez. These are pivotal moments when there were claims that, in fact, to have a right meant to have the material basis to exercise that right, and the court said no. But you also get, I think, neoliberal ideas about states and markets and who people are in a lot of different areas of public law. So I've worked some on free speech and the First Amendment. You get the rise of commercial speech protection, which does not exist until the 1970s, and you get a very particular acceleration of protection of corporate rights against discrimination, for example. You get the campaign finance rules, right, which help, of course, in a way that I think is very resonant with law and economics ideas, that money is speech, right, that you should just treat the political marketplace like a marketplace and then assume that, like, spending has to be freed in order to allow us to be competing in the realm of political ideas, right? You get rise of regulatory takings law, you get, I teach IP, you get the constitutionalization of certain kinds of laws like trade secrecy law. So again, encasement of certain kinds of power in markets, very important if you think about the information economy. And let's say, who controls algorithms or AI today. So you get these kinds of developments. In administrative law, the rise of cost-benefit analysis, which is introduced as a sort of technique of governance at this time, and in a way that is, in fact, distinctly anti-regulatory. And public choice theory, which I think also kind of has influence in a variety of areas of administrative law and public law. And again, sort of starts to do this thing that I was describing as the way economists talk about political economy, which is like, you hear, and I used to, like, I hear, and then of course I mimicked it because that's how you become literate in the law, like the language of rent seeking. So all these kinds of languages come to suffuse conversations, and they have an implication, right? The idea that let's say, of rent seeking, part of what's behind that is a whole apparatus of public choice theory that says, like, the legislature is just a place where we're bargaining over interests, which would mean that it's not a place where you could say, what's right? What should the public do? And that the public would be a place where we argued about that, as opposed to just traded off one another's interests. Okay, so broadly speaking, the shifts that I think we're trying to cash out as the 20th century synthesis are not happening just in academic circles. They're also moving out of the academy from the high peaks of Mont Pelerin through the Chicago School through very deliberate funding and advocacy efforts. So this is a book about the rise of the conservative legal movement by somebody who actually admires pieces of it, Steve Tellis. And it tells the story of the Volcker Fund and the Olin Foundation and how they funded the rise of both law and economics and originalism, actually fused together, and helped create judge schools. So this is an empirical paper that actually does a lovely job at it tracks the panels that judges sit on, who went to this judge school that was funded by the Manny Center and done by the Manny Center, and shows that it in fact had a measurable impact on judgments about the economy. Interestingly, it also shows harsher criminal sentences. which I mentioned just because, again, I think one commitment that I have, and I think many of us interested in political economy has, is like trying to not adopt an old school version of the economy such that it's only in the place of the, the factory or the marketplace, but we can see how there's a sort of intertwined relationship between the kinds of entitlements that we have as people, including as workers and vis-a-vis the state and the way the economy is shaped. Okay, so which is to say, like the story that I'm telling you is also, and that we're trying to trace, is also a story of a very deliberate cultivation of a set of ideas and bringing them into both the judiciary and law and law schools. And so obviously part of what LPE is trying to do is both understand this and contest it. I want to leave some time for questions, so I'll just go on for a couple more minutes. So one question that I get as people have become interested in sort of what is it that law and political economy thinking is and where does it sit in legal thought, is sort of like, how does it relate to other schools of legal thought? Now, this is my view. It's not, and there is no single, it's like any other crowd of people trying to write about things, whether law and economics, or you can draw certain threads that connect them together, and then people disagree about a lot of things. But this is how I would sort of put things. So if you were to think about the evolution of different kinds of legal theoretic moves in American legal thought, if you start with classical legal thought, right, the evolution of sort of Langdellian restatements, right, think about the way that the crits describe the evolution of classical legal thought. On the one hand, realism comes out of that. And after realism, you get sort of neo-formalism and idealism. So this isn't exactly a time series, but and then I would say, out of realism, you get things like law and economics, critical legal studies, critical race theory, and out of neo-formalism and idealism, you get things like legal process theory, legal liberalism, the new private law, and originalism. If you orient yourself to the world that way, here's where I see us, and here's where I see the 20th century synthesis. So the kind of broad synthesis, the kind of prevailing wisdom, sort of, I would say, is operating up in the sphere of blue. So to construct this idea of sort of, on the one hand, a private that's governed largely by efficiency, being contested, of course, by some of the new private law stuff, but that itself is not thinking about political economy in a way that opposes law and economics, but rather thinking about sort of individual rights or individual sort of deontic values. Legal process, legal liberalism. So that there's that, and then I think broadly what LPE is trying to do is draw on realism. In some pieces, law and economics itself is particularly the first wave of law and economics, which if you look at Barbara Fried's book on Hale, the legal realists she describes were the first law and economics movement, but they were very institutional. They thought about the economy very differently than neoclassical economics does. And drawing on in various ways parts of the crit tradition, parts of the critical race theory and feminist tradition to try to contest the 20th century synthesis. So that's my attempt to sort of situate us in legal thought a little bit. I promised to say before I stop a little bit about also what comes next. So maybe rather than say more about these different pieces of legal thought, which I'm happy to come back to if people are interested, let me say a little bit about what comes next. So where's all of this headed? What are people interested in doing with this thought? So here I guess I'll just point you to a bunch of things to read and think about, which is to say, broadly, I think a lot of what people in the world of law and political economy are trying to do is contest the rise of private power and concentrated private power, and so to shrink it. So one example of that is, it's very interesting because law and economics first took hold in antitrust. And in fact, that's where I think the LPE ideas have had their most sort of obvious impact because, Lena Khan is the chair of the FTC. And also helped me make the first LPE course at Yale. So broadly, people like Lena Khan, Sandeep Vaheesan, Sanjukta Paul, they're all thinking about how to revive so-called Brandeisian theories in antitrust that would in fact look to the statutes of antitrust and say antitrust has a history that in fact Congress was thinking about when they wrote antitrust laws, that thought about the problem of the political power of big business, and that gave us tools to in fact make private power more accountable to democratic will. And so we're trying to revive some of the tools that antitrust and consumer protection law gives you to, for example, like contest the way that non-compete rules are imposed upon 30 million workers in the United States today. So there's work of that sort. In antitrust, there's work on reviving labor, and some of that, of course, reviving new forms of labor law, but also challenging and arguing that we should transition to something like sectoral bargaining in labor law. I work on pharma and healthcare, as do people like Allison Hoffman, who are thinking about sort of what's the role. A lot of my work is about not just addressing high drug prices, but also generating more public investment into R&D and thinking about public infrastructures for development of medicines and so forth. I think there's also a broad strand of work that's thinking about how do you build more robust forms of power for ordinary people. With the decline of union power, that has not really been it's been not very hard for ordinary working people to have kind of a measure of political power. There's obviously, you could link the labor law work here too, but also there's interesting new work on constitutional law that both tracks questions about judicial review and the power of the courts and the way that courts can tend to, and historically have tended to, in fact, also defend concentrated economic power and the power of elites, and sort of challenging that, and thinking about what kinds of structural reforms you might need in our constitutional or kind of structure of our political order in order to remake a more democratic economy. There's work on criminal law and decarceration by people like Amna Akbar, Jocelyn Simonson. There's a lot of interesting work on housing that, again, is sort of fusing questions of how to better protect people's ability to have a home with ideas about organizing and how to build organized power through, for example, tenants unions. People interested in sort of rethinking the law of the administrative state and how administrative law can be more responsive, not necessarily just simple proceduralist ideas, but to the need to build power among working people. So there's a kind of law and organizing strand that people in LPE are very interested in, so conversations about sort of can there be reforms that aren't reformist, but that in fact help build power towards more transformative ends, and emphasis on the building of organized power, as I was saying. So here's a couple more things that you should feel free to have a look at if you're interested in this. So these are a couple of framework pieces, the one I mentioned earlier in the Yale Law Journal, and another that is a sort of orientation to law and political economy. And then, of course, our blog, which has hundreds of people who've written for it, and is only, each piece is about 1,000 words long. So you can do that. And we're solving the greatest problem of legal scholarship today, which is the length of law review articles. So, with that, I will end and look forward to your questions. And maybe just say who you are, since I don't know most of you.
I'm Mary Tate, and I'm on the law faculty here. I run a clinical program that's wrongful convictions. But so political economy, and I think you were saying in the beginning that it's an interrelated loop, right? I mean, mutually.
Yes, that is how I feel, exactly. Okay. The law constitutes or politics constitutes the economy, and the economy constitutes politics.
Yeah. And then what struck me is your reference to Marshall's use of the word conquest, and then the Coase theorem and efficiency. Bill Clinton knew that the Coase theorem and the getting rid of Glass-Steagall and NAFTA and various other measures were conquest in nature. So the question I have for you, and I'm sorry it's so political in nature, but we have a political ecosystem where the Democratic Party, as currently constituted and for 35 years, is playing games with words. And they actually adhere to a notion of conquest. So,
Question.
where's the way out? So my question is, where's the way out?
Yeah.
I mean, I just...
Okay, cool.
I'm sorry.
That's
that
it.
it-
Don't apologize. I believe in asking the hard questions. I mean, I guess I want to say two things about that. One, the reason I ended up on organizing is that I'm a real believer that, in fact, you know, if you want to envision very substantial change, some of the students and I were reading and talking about this earlier, that I think law schools should teach more about organizing, should teach more about how lawyers interact with not just movements, but also can help structure more power for ordinary people. So take the example of the labor union and say, what happens if you bring that over to the tenants area or welfare? Or, you know, like, how do you think about sort of proliferating institutions of organized power? Because fundamentally, I think law organizes power. And if you know, people are going to have power over their, you know, over their lives, we need to organize power for them. You know, so I think the answer is organizing, and so one thing that I think is there's opportunity in is that there's a more diverse set of political voices out there now, and there is, you know, renewed interest among the young in labor organizing, in thinking about organized power, and maybe a little bit of I think more realism about the problems with sort of spontaneous, you know, like let's all just gather like on Twitter or something like that as an expression of political power. But the other thing I think I would say is that I experienced a change also even in the kind of class of people who go to Yale Law School, who is Bill Clinton, right? I think that some of the ideas that I was describing, you know, people didn't really, I think, fully understand the implication, like of the, you know, now that people have written about the China shock, I think you do find some people who actually have changed how they think about the trade order, for example. And we are seeing some shifts, you know, in the conventional wisdom, right? So industrial policy is back. I've been writing about that. I think the U.S. orientation toward trade is changing. I actually think there are some cracks broadly, even in more elite institutions and the halls of Congress, thinking about this world order. What I think is really interesting is that could go in multiple directions. When I teach law and political economy, I teach Carl Polanyi's The Great Transformation. If you've read that book, he's writing it on the edge of fascism. It's in 1944, not the edge, but he's writing it he's had to flee Europe because of the rise of fascism, which he attributes to the gold standard and the economic crisis that followed. And he's very plain. Part of why I teach it is he says, you know, the picture of the self-governing economy will always undermine society. Society will rebel, and that can take two forms. It can take the form of fascism. In his words, he says fascism or socialism. So I think we're in a moment where we are seeing a shifting ideas of political economy, but it could take different forms. And so this is what I think some of the contest over the next many years will be. Will there be a real new political economy that evolves out of it, or new ideas, and which form will they take? Because they needn't take the obviously fairly progressive form that I've sketched for you. They might take a very different form.
Thank you so much for being here. I enjoy reading the blog, and I really appreciate 1,000-word pieces. My question is maybe a historical one. I wonder whether or not the tendency towards efficiency and Coase theorem style responses is the interest or maybe need to measure things, right? So you're in an agency and you're going to require airbags, and you've got to explain to the world why we need airbags, and they justify the $1,500 cost or whatever. It's almost as though once we talk about the cost of the airbag, we then are forced to monetize everything else, right? So it's almost that we don't have a coherent way to assign value to lives other through than monetization, right? And I wonder if there's strands in the LP movement that sort of address that challenge, because I always think that, I mean, as much as I agree with a lot of this, I'm like, okay, so I'm in an agency, what do I do now?
Yeah.
So I'll leave it at that.
I mean, so I do think that there have been interesting attempts to like kind of think about how to change cost-benefit analysis, for example, to include other kinds of distributional issues and so forth. And so, like, one question is, can you quantify differently? I come from the health field where there's a lot of quantification, but the metric that people use is like disability-adjusted life years. And you end up with a very different result if that's your metric, as opposed to sort of some sort of willingness to pay market modeling metrics. So one thing is one could still envision metrics, but change what those metrics are. But the other is, I think, some of the work in administrative law that I was describing, I think people are trying to think about what are other means of sort of disciplining and shaping power in the administrative state. And we have other traditions for doing this. You can think along corporatist lines and say, like, well, what if you put together different organized parties and say, like, they can dispute and kind of debate over this. You can think about participatory logics over a kind of a cost-benefit. And I think the more you see about cost-benefit analysis, actually, the more the ideal that it's rational and in fact incorporates all things becomes implausible. Like, it's not, it incorporates all things, it incorporates things you can measure. It often, if you really, like, last time I taught about cost-benefit analysis, I taught the cost-benefit analysis of the Stop Prison Rape Act. And, like, it's wild to read because, it's a very good document to show you that you can't really do let's just solve this with some clear and tractable numbers. And if you were to do that, one of the interesting things about the cost-benefit analysis is the way it's situated in the administrative state. It only defeats regulation. It doesn't generate it, right? Well, that's not science. Like, that's a very particular way to deploy that tool. And so once you, I think, uncover those kinds of things, I think you can also really make a lot of headway in contesting the very idea that there's magic to numbers and that there isn't a politics to numbers.
This might be a little bit of a difficult question, but if you're not a scholar and you're not the chair of the FTC, how do you bring law and political economy into practice if you're just a regular lawyer?
I think there's a lot of people who are, in fact, doing that work, and some of that you'll find in our blog. And like, one of the reasons 1,000-word pieces are great is we have hundreds of them, and we're probably more than that. And you can just go look, like, what do people do who are, what are people who are interested in the green transition working on, or what are people who are interested in utilities, or what are people who are interested in decarceration doing? And so I guess there's both a lot of ideas there for the kinds of work that people are doing, but I'll also give you the pitch that I gave to some of the students that I met with earlier, which is to say, one of the things that I think those of us who have a more ambitious horizon for sort of really democratizing our economy, changing the shape of it, and kind of addressing whether it's the climate crisis or the care crisis or carceral crisis, is thinking more about law and being a lawyer through thinking in more diverse ways about that than thinking about either legal services or litigation, but thinking like, what's the model of the lawyer that helps facilitate tenant unions, right? That's a different way of lawyering. You need a lawyer to pass a law that says tenant unions can have protection. We have a law in New Haven that allows tenant unions to be recognized as part of our Livable Cities initiative. And that helps enable mobilizing, and people are working now to mobilize across different kinds of really pretty terrible industrial landlord situations in New Haven. Though it's a different kind of lawyering. So I guess that's part of what I would encourage you to do, is take some of the materials you find in this literature and on the blog and think about where you can do what you think needs to be done from inside of the frame of litigation. Direct services, great. But often, if you have ambitious aspirations, you're going to have to think about lawyering in a different realm in relationship to helping build organized power, helping movement strategize about how to make gains that can grow over time. So that's the best I can do to your very good question.
Thank you.
Hi, I'm on the faculty here as well, and really glad that you're here. It's kind of a dream for me, fangirling. A lot of my students are in this room, and thank you for coming, students. And I was wondering if you might be able to say a word for them about necropolitics. I saw on the blog a couple days ago that somebody posted on the LPE blog about the necropolitical, and we've been talking about that in my classes. When I teach contracts, we teach like Williams versus Walker Thomas Furniture, and right, these like horrible deals that people get into. There's Older Reetsy versus Bloomfield, where you have the queer teacher who's forced to like resign in the middle of the night. And when you think about like it from like the Lochner perspective, it's all about the right to contract, or it's the right to work. But right now, post-COVID, you're seeing a lot of, right, yes, you have the right to contract with a landlord for a horrible, right, apartment, and then everyone dies, right, either because the building burns down or everyone is infected and there's not a lot of stuff. Is there something you could say very briefly about what, like to contextualize necropolitics within the LPE framework and legal education? And I know that's too much, but just a word for them.
Great. So one way to think about this, when I teach my LPE class, we do start with Polanyi. And one of the things Polanyi starts with is the idea that the introduction of a kind of market order in what he calls market society. So you could talk about it as capitalism or market societies, but the transition from feudalism. Really, part of what it did was it disrupted old social orders where there were the kind of older forms of ensuring that people, kind of maybe collectively would be able to have access to land or operate in certain kinds of social solidaristic ways, and leveraged what Polanyi says, like people's hunger against them, right? And so the idea that you kind of work or starve, right? So you're pointing to the sort of tradition and thinking about necropolitics makes me also think about the health justice questions that I work on and how, there are really important ways that trying to insist on the particular kind of market order of, like in the neoliberal era that we live in, really has proven deadly for people, and not just in ways that had to be. I think that's the story we get told. Like, it has to be this way. There isn't any other way to do this. And I can just tell you, as somebody who came into the AIDS movement, and this is where I started, so it's a good place to end, we were told the same things. It had to be this way. The drugs had to be that expensive, and it wasn't true. And guess what? Those drugs now cost less than $100 per person per year. There are millions of people on HIV treatment. It has not destroyed drug development. Come talk to me if you want to know how that magic all happened, but a lot of it has to do with the fact that those drugs were developed through public investment, which is not visible because there's a story that we have that the public doesn't generate things, the private generates things. Those drugs came from public investment, and there were ways, in fact, to make them cheaper. They didn't all flow across borders. The world's a better place, and you can make those kinds of changes, I think, if you're willing to take the problems seriously, and also back to sort of trying to work with organized groups of people who are theorizing and working on how to contest this. So, all right, thank you guys so much.